The morning sun filtered through the tall windows of the halls of justice, casting long and dignified shadows across the polished wooden benches. There was a unique atmosphere in this place, a mixture of heavy responsibility and the hope for a fair resolution. This was the courtroom of Judy Justice, a place where stories of human conflict were untangled with precision and a touch of seasoned wisdom. On this particular day, the air held the weight of two distinct narratives, one involving the bond between horses and their owners, and another concerning a cold rescue mission for a beloved dog named Snowy. The court officer called the room to order with a voice that commanded immediate respect. "All rise," he announced, and the small crowd stood in unison as the judge entered. "Have a seat, please," she said, her eyes already scanning the papers before her. "Good morning, Judge," the room responded. The first case was called number 3028, involving the Alpertson family and a man named Glenn Garaciano. Gabriel Alpertson stood at the podium, her mother Angela beside her. They were there to seek the return of their rental fees and security deposit. The judge looked at the young woman, noting her composure. "Gabrielle," she began, "I am going to speak to you. This is your mother, and you both had horses." Gabrielle nodded, explaining that she was 21 years old. The story of their horses began in February of the year 2023. Before moving to Charleston, the horses had been kept in Charlotte, North Carolina. Angela still lived there, but had plans to join her daughter soon. They had two horses who had been companions for over 6 years. "We did not want to stress them or separate them," Gabrielle explained with a gentle smile. Keeping them together was a matter of love and consistency for the animals they cherished. Gabrielle had been the one to find the property owned by Glenn Garaciano. She had met with him and ultimately signed a lease at the beginning of February. The judge asked to see the lease, and after a moment of technical coordination, the document was presented. The lawsuit sought the recoupment of money paid. While Glenn had filed a cross-complaint for damages he claimed the horses had done to his property. The lease had officially started on February the 12th, though the horses arrived on the night of the 11th. Glenn had been there to welcome them, explaining the specific trough for water and the rules of the pasture. He had admitted he had no knowledge of how to care for horses, leaving that responsibility entirely to the Alpertsons. In the month of February, they had paid him $925,000 for the two horses. The judge paused at the figure, noting the financial commitments involved. By the middle of March, specifically on the 13th, the arrangement had come to an end when two deputies arrived to assist in the removal of their possessions. They had been there for approximately 5 weeks. During that time, 3 payments of $925,000 had been made. One for the first month, one for security deposit, and a third for the following period. It did not work out, the judge observed simply, but Glenn countered, saying it was way more than just not working out. He claimed that the horses had caused damage to the pastures. The judge, ever pragmatist, focused on the essence of the matter. This was not about personal feelings or shared grandchildren. It was about the security deposit of $925,000. Glenn argued that the animals were not adequately cared for and had eaten up his pasture, leading him to terminate the lease. The judge examined a specific document presented by Glenn. She asked Gabrielle if the signature on it was hers. Gabrielle confirmed that it was. She had signed it on the day they left. The document served as a receipt for the final month and stated that they had agreed the deposit would be forfeited to cover some of the damage done by the horses. With that signature, the legal standing of the case shifted significantly. A contract is a contract, the judge explained. Gabrielle, at 21, had signed an acknowledgement and an agreement to forfeit the funds. The judge noted the use of the word sum in the agreement. It was a specific choice of language that allowed for the possibility of further claims. Yet for the purpose of security deposit, the matter was settled by the signed document. Glenn had kept the $925,000 to cover the stable damages, and the judge ruled that the case was dismissed. The legal argument had reached its conclusion, leaving the emotional weight of the 5 weeks behind. As the first group departed, a new story began to unfold. Case number 2203 involved Susan McCauley and her neighbor, Ed Wadsworth. This was a story of a rescue mission and the unexpected cost of a good deed. Susan was suing for towing fees and vehicle damage. The connection between them was a mutual friend who was Ed's partner. Some time ago, a beautiful dog had been rescued. He was a white, majestic animal, the kind one might imagine pulling a sled through a frozen wilderness. They named him Snowy. Ed spoke of him with great affection, showing a picture of the dog on his phone. We had a golden retriever that lived to be 16 years old. Ed shared, his voice softening. Snowy had come into their lives about 7 months prior, found running around by a friend, and rescued from the streets. The trouble began on a cold day in January of 2023. Snowy had gotten loose and disappeared. Ed had spent hours driving around, searching for his friend. Eventually, the call for help went out to Susan. She was asked to bring her own dog, who was a buddy of Snowy, hoping the familiar scent and presence would help lure the lost dog home. Susan arrived in her truck, accompanied by her roommate. They met outside Ed's property. The ground was a treacherous mix of snow and mud. In the process of searching and attempting to navigate the difficult terrain, Susan's vehicle became stuck. Ed, attempting to help, also found his truck trapped in the mud. It was a classic scenario where a well-intentioned effort led to a mounting series of complications. A tow truck was eventually called to extricate both vehicles. The bill for the service came to $330. Susan had paid the full amount and felt that Ed should be responsible for at least half, as well as the damages to her car. The judge listened intently. She noted that while Ed had not directly asked Susan to become his girlfriend, the circumstances of the rescue were a collective effort. Legally, there was no liability for Ed to pay for the damages to Susan's car, since he was not driving it when it got stuck. However, the matter of the towing bill was different. Both trucks had been stuck in the same mud, and the same tow truck had provided the service to both. The judge looked at Ed and asked why he should not be responsible for half of the $330. Ed explained that the tow truck driver had to use a long cable to reach Susan because the ground was such a mess. He felt the situation was complicated, but the judge remained focused on the fairness of the shared service. "You know the 3 most difficult words for a man to say," she remarked with a hint of a smile. "Besides, I am sorry. How about, yes, I am responsible?" Ultimately, the judge ruled that Ed owed Susan $165, which was exactly half of the towing bill. It was a fair judgment that acknowledged the mutual predicament they had found themselves in. As the proceedings concluded, there was a sense of relief. Snowy had been found and was safe at home, though the journey had been difficult. He had even suffered an injury to his leg during his time away, necessitating an amputation. But he was resilient and loved. Susan, despite the cost, expressed that she would do it all again for the sake of the animal. The judge reflected on the day's events with her colleague. She noted that the first case was a matter of clear contracts, while the second was a reminder that no good deed goes unpunished. Yet some deeds are still worth doing. The principle of rewarding favors and being grateful for help was at the heart of the matter. The courtroom emptied, leaving behind the echoes of resolved disputes and the quiet dignity of justice served. The lessons of the day were clear. Legal arguments require evidence. Contracts demand respect. And even in the face of unexpected costs, the bonds we share with our animals and our neighbors are things that truly define our humanity.